Move on then to the motion to dismiss claims for failure to state ultimate facts sufficient to constitute the claim, and that one was filed 12/15. And a response to that was filed March 4th as well, I think. Yes.
Your Honor, I have no record of that. I have listed documents filed in March.
I'm looking at it. It was filed.
I see two opposition to motions to compel.
And it was mislabeled. The second one is the motion or the opposition to that motion. That one out real quick.
And I didn't get that in the mail either, so we're not prepared to deal with that one.
Your Honor, I'm not sure about the mailed copy, but as demonstrated by our certificates of service on all of those oppositions to the motion to compel, they were served by email, which was permitted. Then you have the additional 3 days for mailing. Whether or not they received them, I have no control over that. We've just represented to the court that we put them in the mail, which we did. I guess we're asking the court to deny additional time to respond to those.
Go ahead, Mr. Dyke. You had something else you wanted to say?
Yesterday, we did not get. She certifies right here on March 4th. She mailed these things, and we have yet to receive them.
Well, it sounds like you've got a printout of what was filed. So hang on. So you were aware this motion was pending. You filed the motion.
I haven't been speaking with my email.
Well, that's not my issue. Do you have anything else you want to argue on this motion?
Here we go to your forum on March 4th and March 5th. When did she do what? I certified March 4th. I served the plaintiff's public. I'm emailing them. Okay, so she emailed on the 4th. She mailed on the 5th. We haven't gotten those.
Okay. Do you have any additional argument on your motion?
Oh, absolutely. I'm sorry for any disrespect. This is we're trying. We go back to Warburton. This is not sufficient to state a claim. A plaintiff was a felon, and he filed a complaint, and he didn't state in his complaint that he was a felon. Another party demurred on the grounds of he's a felon, he doesn't have grounds to sue. If their defendant's motion to dismiss, he denied because he said they would say, well, we know he's a felon, but he didn't say in his lawsuit that he was a felon. You can't use a motion to dismiss an action by a felon on those grounds. Is that not correct?
That's not correct.
There's Slopak versus State of Oregon from our first motion, which we didn't get to discuss, where a felon tried to sue the correction system. And then you heard on he's a felon, he has no right of action. Well, here we have a person that purports to be a possessor that is proven to be not a possessor. And, we're looking for the right term. He doesn't have capacity to sue as a non-possessor. He doesn't have, his facts are not facts. They are error. facts about possession have been proven to be error. There's a rental contract initiated as of 2017. The property is in the possession of not one but two parties, a family and their business. There's contract records if you look at that. So perhaps you can suggest, maybe we can't do anything with this until the trial. And finally, in a trial, we can say, okay, now what we brought up all along can be addressed. Proven that this man is not in possession as he contends in his complaint.
Ms. McLeod, anything on this motion?
Your Honor, I think we filed a pretty brief reply on it, which was just simply that he's filed a motion to dismiss for failure to state a claim. If you look at the amended complaint, there's numerous references to why Mr. Byers is entitled to assert this claim, and all of the argument is taking evidence outside of the pleadings. So we would ask the motion be denied.
Okay. So as I mentioned before, typically a motion to dismiss, certainly one made under ORCP 21A, needs to be made before pleading or filing an answer, which obviously you've already done in this case. But in any event, a motion to dismiss for failure to state a claim, the court needs to read the complaint, or in this case, the amended complaint, in the light most favorable to the plaintiff, and I'm required to do that liberally. And Mr. Byers has alleged sufficient facts to constitute a claim. What you're attempting to do is to provide facts which in their current state are really just allegations that counter the facts that he's alleged in the complaint. That's not an issue that the court can resolve on a motion to dismiss.
Let's say ORCP 21G3, a motion, a defense of failure to state ultimate facts constituting a claim, can be made by motion for judgment on the pleading or at the trial on the merits. So I still have an opportunity for motion to dismiss.
At the trial, certainly.
Or before.
At those points that are outlined, yes.
Can the court suggest anything we can do with our obvious evidence?
Contact a lawyer and get legal advice. I can't give you anything beyond that. But as I was saying, the present motion really is attempting to counter the allegations that are made in the complaint. That's not an appropriate determination for me to make on a motion to dismiss. It may be appropriate at trial or by another method, but it's not appropriate on a motion to dismiss. So I'm going to deny that, which then gets us to the motions to compel the requests for production sets 2